Hey, I'm Paul Rabelais. So in this video, I'm going to talk about what to tell your kids about the content of your estate planning legal program. People ask me all the time, Paul, how much of all this should we tell our kids? And when I say kids, I'm really meaning heirs. Some people leave stuff to their kids. Some people don't have children or leave things to people who are not their children. All that's good. I'm just going to refer to as kids because that's usually the questions that's asked of me. But it's really a personal decision. I'm going to break it down to two components. The first is how much of what you own do you tell them? The second is should we tell them why? So the first component, do you tell them what you own? Two schools of thought. Some parents come in and they say, Paul, our kids have no idea what we own and we're not going to tell them. And when they usually tell me that, they usually have more than they think their kids think they have. So just to put numbers on it, maybe the parents saved, invested, and were frugal and they have a couple of $1,000,000, and maybe they think the kids think that their parents have maybe a couple of $100,000. So the parents say, we're not going to tell them. And they may say that for a couple of reasons. They may say, we don't want our kids to have an expectation that they're going to get this big chunk, and it might make them lazy today knowing that they'll get, $1,000,000 tomorrow. Or maybe they're thinking to themselves, we're going to spend it all anyway, so why tell them we have what we have when we're going to spend it? Although, most parents who were frugal and saved, they don't just flip the switch and just start spending like crazy. So nonetheless, some people say, we're not going to tell them. Other people say, we are going to tell our kids everything we have. We've already told them. And most people who do that, they want it to be a learning process for the children. Maybe they can share with the children how they saved and were invested and were frugal and built an estate. So maybe that could have, if they teach that their children what they did, it may have an impact on their children. Their children might be able to do the same thing and retire comfortably one day. So two schools of thought there on, do you tell them what you own? The other issue, probably more important, is the why you made certain decisions. Probably communication is a good idea here. You're going to be making lots of decisions when you create and maintain your estate planning legal program. Some of those decisions that you'll be making are, do you leave things to your family or your heirs through a will and require that they go through the probate process when you pass away, or do you leave things to a trust and try to eliminate the court involvement? Other important decisions that you'll be making, do you leave things at the end of the day to your children equally or do something other than that? Do you leave things to your grandchildren? Do you leave specific assets to certain people, or do you leave some kind of unequal distribution? People commonly leave things to their children equally. I don't know that really requires a why communication, but some of the other decisions really do. If you leave things to grandchildren, some people in their mind, they're thinking, well, because of some prior life experiences, I want to make sure something's left to my grandchildren so that they can either get an education, get a head start on life, because they feel like leaving it to the grandchildren makes it more likely that the grandchildren will get an education than just leaving it all to the children. Sometimes people leave their home or a specific piece of real estate or a specific sum of money to a certain person, or a specific vehicle to a certain child or grandchild or other person. So communicating why, you may have what you feel like is a very valid reason for that. But if your survivors don't know your reason why, it could cause some hard feelings. Maybe you leave a larger amount to certain children, a smaller amount to others. Who knows? Maybe you feel like you did more for one or more children during your lifetime than other children, so you want to equalize it through the inheritance. Again, if you don't communicate why, it could cause some hard feelings and some, I wonder why mom or dad did that. You're also going to make certain decisions on who is going to be handling things when you become incapacitated or when you pass away. Who's going to handle your money when you're incapacitated? Who's going to make your medical decisions, be able to talk to the doctors, go get your medical records? Who's going to be involved when you pass away with the sale of the house and the distribution of the assets? Who's going to be your executor of your will, your trustee of your trust? And so real important that you communicate the why. Some people feel like, well, I'm designating this person because they're the oldest, or I'm designating this person because they're local and they're responsible and they are organized. Or maybe I'm designating these two people because they have relationships a certain way. And again, if you don't communicate the why you're doing that to the people that you're leaving behind, it could cause some hard feelings. So really communicating the why you're making these decisions is important. That end of life decision, life support machines, the living will decision, real important for you to communicate your why. Not that the survivors can do anything about it, because if you've made a living will, in most cases you've made your decision directing them to honor it. But the why and your wishes behind that can make things easier down the road. So when you communicate your why or your what, how do you do it? And so that can be done in a couple of different ways. That can be done either just by having a conversation. People tell me, Paul, once we have all this in place, working with your office, I'm going to sit the family down. I'm going to get everybody together, and I'm going to have a real good communication. I'm going to show them what we did, and I'm going to tell them why we did it. Other people don't want to have that kind of big kind of personal open discussion about it, so they will want to do it in writing. And so people say, should we put all this why and what we own in the legal documents, or should we do it in some kind of separate written communication? And I always say, the legal documents isn't really the place for the why. A separate communication may be done in your own handwriting, type it up, whatever, informal. It doesn't necessarily have legal effect. It's just the letter as to why you've made certain decisions, which makes everybody feel better down the road, so at least they know. So there's certain ways that you can communicate that why you made decisions, and so that becomes real important. So in summary, communicating what you're leaving behind or what you own could go either way. Strong decisions and arguments can be made for not telling the future recipients or telling the future recipients the why you made the decisions. I think communication is important, so they're not left wondering, and why can either be done in a personal oral communication, or it can be done in some type of written letter format, handwritten in your own handwriting, outside of the formal legal documents that have that legal structure and all the legal mechanisms to back up your why. So hope that helps. I could go on for hours about right and wrong ways to communicate, what to communicate, but that should give you an idea of how most people feel when they put this process in place of trying to keep things in the family and pass it along to the next generation or two the right way, and keep those family relationships intact, if not even prospering. I'm Paul Rabelais, estate planning attorney. Hope that helps. Y'all have a great day.